I'm Asmita and I am a lawyer. I graduated from the National Law School in Bangalore, and the first year of my career actually did corporate law. But then I decided that I wanted to work in the Supreme Court and on human rights. So I came to Delhi and I joined Ms. Jai Singh, who is the director of the Lawyers Collective. But at that time I didn't join the Lawyers Collective, I joined her as a junior in court, and she used to handle a magnificent array of cases, human rights violations, environmental rights, a lot of labor rights cases and so on. So that's what I did, and then I went off to do my LLM, and at that time I did a little bit of an internship with Amnesty International, and I came back and I joined the Lawyers Collective, and I was the coordinator there from 2002 to the end of 2008. And after that I left the Lawyers Collective to do a fellowship. I got the Fulbright to go to the States to do a research fellowship. And from then on I've been working on my own. And in the last year I have had the opportunity of working in Bangladesh, in Laos and in Burma. So it's been quite interesting. But on the same issue, which is violence against women and how laws could be used to address it. I like the aspect of interacting with people the most. Of course, I must say that it's been a very long time since I've actually interacted with women clients. But it's still quite interesting to interact with everyone else. And my research, the stuff that I do even now, is based on a lot of field interactions. So that really is the best part, and also I find it quite fascinating to work in different countries, because there are many similarities, but it's also interesting to see how those things work out, because it was absolutely fascinating working in Laos, which is a single party system. It's a civil law system. It's very different from the common law system as a whole, but at the end of it, you do feel a sense of solidarity, because the issues are quite common. It's been a lot of different people. Sometimes it's organizations. For instance, in Bangladesh, I was working for a project called the SAFE Project, which brought together 5 different organizations to do very focused work on adolescent health and sexuality and safety in 5 slum areas in Dhaka. So I was called to that project, but it was kind of an NGO coalition where I had to do some broader policy kind of research and put down protocols for how their legal aid cell was going to function and so on. So that was in Bangladesh. And in Laos, I was actually appointed by the National Assembly of Laos, because they are reviewing their laws on violence against women to see how it's working, whether it's effective in addressing domestic violence particularly. So that was for the National Assembly, though I was brought in by the UN Women. Similarly in Burma, it was a very short project where I was again helping some of the civil society groups in Burma, but again through the UN. So I've done a couple of projects for the UN, slightly more global kind of researches on violence against women. But there have also been organizations. For instance, last year I also did some work which wasn't related to violence against women, like on beggary laws, and on security laws. So I try to do other things as well, but it's a mix of the UN and other NGOs mostly. It's been quite a long journey of working on violence against women. When I joined the Lawyers Collective, the Lawyers Collective had already taken an initiative to draft a law on domestic violence. And the reason why they wanted to draft the law on domestic violence was based on their practice of providing legal aid to women who were facing violence. In fact, a lot of our laws are British laws, like our penal code is the British law. Of course, there have been some additions which have been made and some amendments and so on, but there's a lot of stuff which needs to be reflected upon, like we have exemptions of marital rape, causing of miscarriage, and therefore abortions is a punishable offence. Of course, you have the MTP law, but it's still, there are some grey areas there. So So yes, we still. In fact, it's not only India. It's India, the entire subcontinent, plus Burma. Singapore has the same penal code. Hong Kong, Malaysia. So there's a lot of the countries which are continue to use British laws. Yeah, and also the thing is that the way in which the British kind of ruled allowed that to be quite entrenched, because what the British way of ruling was that they secularized all the laws that were required for administration. Right, so you had a penal code which is secular, you have the procedural law which is all secular, contracts, service laws, labor laws, all secular. But what happened in the personal space, they did not legislate on. So the personal space is governed by religious laws, by cultural practices and so on. In those areas, there is a lot of scope for discrimination. I mean, not all of them are compliant with equality standards, which were later adopted at the time the countries got their independence. So those things require a relook and a revisit quite urgently. The success of the Indian law is that it takes international principles, but it is able to apply those international principles into the existing system. So it builds on something. So, I mean, if you look at it, the whole law is made in a manner which is able to put in place a very quick procedure, and from courts. So to that extent, it is a success. Yeah. So that is the success of the law, that it is very locally applicable, it builds on existing structures, and it kind of takes into account what there is and what can or cannot work, and it gives direct access to courts. Now I'm working in a lot of other places like in Laos and Burma. The thing is that I'm working, looking at the laws on violence against women, particularly in the ASEAN region. Particularly in the ASEAN area. And the thing is that a lot of these laws are extremely progressive, but the implementation is a problem. And sometimes that gap between the international extremely progressive standard and the way in which it's going to work out on the ground is quite broad. So I think the Lawyers Collective serves as a good example of how perhaps both of them can be you can bring these two closer, and also have it has a very kind of hands-on experience of what could or could not work. So I think these lessons are quite valuable and can be used in other countries, particularly in this region, which have laws which are a little more recent than other regions. Like for instance, the Bangladeshi law on domestic violence got enacted last year, and the Pakistani law got enacted this year. So I think there could be some mutual exchange on what has worked from our end, because then they'd be able to factor that in their implementation. One of them was to recognize cruelty within marriages as an offense. So you have a very strong law on cruelty within marriages, but it has its limitations because it doesn't cover all domestic relationships. Because people are not necessarily always married, there can be mothers, sisters, etc. That was one. And the second thing is that a lot of the times when women would try, like if they were facing violence and they did want to do something about it and go to the courts and so on, the minute they would register a criminal complaint under the provision, they would get thrown out of their homes. And a lot of the times the native families would not take them back, and so they literally had no place to go. So the right to residence was not there, and it was a huge problem. The reason again the right to residence wasn't there was because you have property, the inheritance and property regime, which is governed by religious laws, which are in a lot of cases discriminatory. And also given the patriarchal structure of the society, household ownership or any kind of title is usually in the name of the husband or the patriarch or the male member. So women don't have a right to property in most cases. And if you don't have a right to property, then you don't have the right to reside. So, what Ms. Jaising, my senior, whose whole idea of this was, she said that it's quite easy to throw your dependents out of the house, in the middle of the night or whatever, but not so to throw your tenants out. So you may have a tenant and the tenant hasn't paid you rent for many, many years and months. But if you want to get the tenant out, you'd have to go to court, get an eviction order, and only then could you throw the tenant out. Whereas with the dependents, they had no right to stay in the house, so you could throw them out at any time. So that was a huge issue that was facing women. And also, again, the way in which it works, mostly the men are the breadwinners, they are the providers. So having a criminal case against them would have other effects, because the woman wouldn't have any money, the children's education, etc., etc. Who was going to pay for it? So a lot of the women who came to the Lawyers Collective at the time would say that, what's the point of him being behind the bars, because, it's, where will we go? So that was the other thing. And then, so there was a lot of problem with the way the law was. So what Ms. Jaising thought was that, way you can counter these problems is to have a civil law, which is more relief oriented, keeps the woman in the center, and it recognizes the right to decide. So to that extent, the domestic violence law was quite revolutionary in the way it, brought relief to women. So that was what my first engagement was with violence against women. And then, of course, if you understand violence to be a form of discrimination and a violation of equality rights, and you make that link, then you kind of are able to look at a whole spectrum and various forms of violence through that lens. And if you look at it, the reservations that have been entered are also very cultural grounds. So the Indian reservation is that we will not interfere with the community, and it will be the community themselves who will make the change in their laws. But then there's no definition of community, and who constitutes the community, and who are the leaders of that community. And if we accept that it is a patriarchal world, then surely religious assemblies, organizations, whatever, will also be patriarchal. So quite delightfully vague and not very women-friendly, the reservation. The language of violence is quite similar and common, and there's only varying degrees of it in various forms. But in terms of, here the violence happens to keep the women out of the home, because you're talking about a situation where resources are scarce. So if there is violence and things like that, you'd rather have a dependent out for, and then it's lesser person to, support. And the other thing also is that dowry is still, is an issue. And you do have a lot of dowry-related harassment and all of that happening. And so to that extent, the challenges here are slightly different from the ones there. Frankly, this issue about mandatory arrest and mandatory prosecutions, it's a very tricky one, because sometimes, because a lot of the times when the Lawyers Collective, the people who are doing legal aid, they'd say that a lot of women would come to them and say that, look, we don't want to break this marriage. We want a violence-free marriage. We don't want to break it. And therefore, the law that the Lawyers Collective came up with, the Domestic Violence Act, is a civil law. So it does allow some space for negotiations and coming back and forth. Whereas, if it is a criminal offense alone, then once you file it, there's no getting away from it. You have to go through all the proceedings, because the state completely takes over the prosecution. Here, the woman is in control, because she can decide on the kind of reliefs, and it does not result in the man's incarceration. But this is not to say that you don't need criminal laws and that criminal laws shouldn't be there. They have to be there. But what I'm saying is that it has to be, the law should be able to provide women multiple options, and the woman should be able to choose. Of course, the choice should be informed and free, but ultimately, that's, I suppose, a perspective from the lawyers and the work of the Lawyers Collective. Our policy was that when a woman came to you, you would give her all the options, and you would tell her this is what you can do, and give her a very realistic assessment of the consequences of each legal avenue she'd want to follow. But ultimately, you had to leave the decision to the woman. She had to decide what she'd want to do, and it was a very difficult decision and a very difficult practice for all the young lawyers who were there in the Lawyers Collective, because they would tell her, you shouldn't go back to a violent home, you shouldn't. But they couldn't give her that kind of advice. They could only tell her about the options that were available. So I think, for women to kind of make what you think is the right choice requires work which goes much beyond the law, where you are able to counsel her, to empower her, so that she can make a truly informed decision. So the people who are reporting it the most, or the people who are using the law the most, are married women. But there are other kinds of because this law has a pretty big outreach. It covers all kinds of relationships within the home, but it is gender specific. So as a result, it is unlikely to cover women who are in same-sex relationships. So for them, because the thing is that when one was drafting the domestic violence law, it's a substantive equality measure. It takes into account that women are unequal and they do not have equal access. So this gives you that equal access. But the point is that, so then it doesn't make sense to give a little push to those people who are already have a higher stature in the society, which is the men. So this law is extremely gender specific. So the respondents, or the people against whom you can file the case, will be men. And women, if they are related to the man or as an addition to the man. But you can't have a woman filing a case against a woman alone under this law. Now, the thing is that you may find, you may say that this does not acknowledge the fact that women themselves are capable of perpetrating violence, and that men can also be subjected to violence. And these are accepted, of course, that's an issue. But the point is that just because there is this law doesn't mean that the general law of the land does not exist. So this law is a substantive equality law which is for women, but that does not stop these categories like men or other women or in same-sex relationships from using the criminal provisions and other tort law provisions to get the reliefs that they want. Dowry is given at the time of the wedding, and that is when the thing is happening, and when the ceremony is happening. And then actually it doesn't really stop there. It's a lifelong process. So you can be asked for at any point of time during the wedding, and especially when children are born. There are certain cultural norms which allow that kind of gift exchange to happen, but actually these aren't gifts because there's absolutely nothing voluntary about them. They're demanded and coerced. So dowry can happen at any point of time, and it's an extremely coercive practice, which and there's a lot of violence, and not only violence but also dowry deaths, where women are killed off. So that's why the Domestic Violence Act allows you to have a case against the husband and the relatives of the husband, which is the same formulation as 498A, again something which was born out of the women's movement. So yes, you do acknowledge that violence, but a mother-in-law can't file a case against a daughter-in-law. The challenge is that you can't, in terms of dowry, is that currently the law kind of penalizes the person who gives the dowry as well as the person who takes the dowry, because it's considered to be an offence both ways. But that's problematic, because if both of them are liable, then who will complain? Though, of course, the woman's family has a slightly lesser degree of culpability than the men's side. But the point is that, first of all, gifts, you can't prohibit gifts at weddings, so there will be gifts, and you can't also prohibit certain kinds of culture, and some people, we've never tried to. I'm sure even you've heard of the big fat Indian wedding, right? Like everybody likes to do it in this magnum way, which is, they tried to control it, but it wasn't a success. So these things are allowed, and as a result of that, it's very difficult to distinguish between what is coerced and what is. There's a larger societal pressure perhaps to do things like that. So it is extremely problematic at that one level. And the second thing is that, it's very widely accepted. So it's never, there are very few, it's of course a wild generalization, but at the time of giving the dowry, most people don't object. It's after the harassment starts, or the woman is sent back and more dowry is demanded. That's when the problem starts. But there are very few, it seems, who will stop the practice at the time of the wedding, so that you just don't give into it at all. But that rarely ever happens. There is a huge amount of acceptance. There's also a huge amount of acceptance of violence itself, and I think that is pretty much there in every society where some amount of violence is tolerated. The law is a very powerful instrument, but it can't be the only thing that's going to bring about change. So other things also have to go together. And I think one of the most important things is to recognize women as equal stakeholders. Unless equality is achieved or even recognized, or it's going to be very difficult to combat any of these issues. Like, we have a huge problem of sex selective abortions, and that is because nobody wants women. So, and you can't have a law saying you must want girl children. That's not the way it's going to work. Women have to be more valued. So yes, the law sets a normative standard. It says what will or will not be tolerated. But ultimately, if there is a lasting solution, it's equality. Until we achieve that, laws will have a limited effect. So that's one thing. And also the other thing about laws is that one has to be a bit cautious about how many laws there's going to be and how much legislation you're going to have, because you must also ensure that it's implemented and ensure that it's drafted in a manner which allows for implementation. Those things have to be quite carefully reviewed. That's why I'm saying, if you create equality, you're creating the knowledge, you're making women take informed decisions. So those things, without that, because see, law also happens ex post facto. It does have a certain function of deterrence and therefore prevention, but mostly it comes into effect once the incident has already happened. So we must also concentrate on ways of preventing incidents from happening and creating awareness, getting women out and making them equal stakeholders. Those are things which must be done, and those are things which have to be done through other channels and not only law. So there must be multi-agency responses. The creation of equality, I think, is the answer. I think the DOWRY, which is the Declaration on the Elimination of Violence Against Women, I think it sums it up quite well when it says that violence is a manifestation of unequal relationship and it keeps women subordinated. So I think it's important to understand the role of violence in society, and the role of violence is to maintain status quo. So even if there isn't violence happening at all times, there's always a threat of violence which will maintain status quo. And this is something which whenever I go for trainings and so on, I ask people that, in India, and I'm sure you can apply it to your own lives, in India there is vast inequalities, right? So I will find myself sometimes driving a car in the middle of a slum where people are very poor, or so when I'm driving there, what is the difference between that person and me? That I have been born to privilege, whereas they haven't, and that is a really unreasonable explanation, that you have your privilege because of who you are and where you've been born. It's not a very reasonable explanation of the vast disparity. So then why is it that they don't come and just lynch me and take all my things away? And the reason I think they don't do that is because they are afraid of a police state and the violence that of the state. So what I'm saying, so if there is an unequal relationship which cannot be justified with a reasonable or logical explanation, then you need violence to maintain that status quo. And I think the family is really the smallest unit of a large system, and I think the power dynamics are replicated at all levels. So a more powerful country will have more arms, and therefore other countries will be scared to do anything, but that's an unequal position which is maintained with the threat of violence. So I think violence is there everywhere, and as long as there is inequality, there is always going to be the potential and threat of violence. There have been times when other social scientists or people with social science backgrounds have come in, and that is, I think, has worked quite well. People who are very strong with methodology, who can design research projects, and activists from the movement who have hands-on experience on what does or does not work. Counselors, because lawyers collective, but it is a group of lawyers. I haven't been associated for a while now, but I mean, there used to be, at least in my time, all the high court and trial courts would say, how those dangerous women from the lawyers collective, which we took as a great compliment. Above all, there was concern for the client and the legal aid clients, and making sure that they were taken care of. And I think that was the most. So maybe they won't be able to give you a lot of feminist jargon and say it, but they were there doing the actual work. Because it is a best practice from really all over the world. There are very few countries which have actually done it in this kind of consistent, uniform, methodical manner. So I think it is a practice which can be replicated in many others.
And for who is the handbook?
For state agencies, but it is kind of because the Lawyers Collective feels that its strength is in understanding the law, because they did draft it. So to give an idea of when you are monitoring a law, what is it that you should look for? What would be the ideal way in which the law should be implemented? So kind of giving you direction in that way. It is for the state agencies, but we're hoping that it can also be useful for people who want to do work in this regard. The thing is that the Lawyers Collective has been doing an amazing job from the year that the bill got enacted. They've been doing these surveys of how the law is being implemented, to identify best practices, to get people, to improve on procedures, to get protocols to go, and just to make sure that the government is doing its job according to what is written in the law. So they've been doing this fantastic job, and they've done it for 5 years, and they've come up with 5 monitoring reports of how the law is being implemented. And so what I'm doing is that I'm just looking at what has happened in the last 5 years and coming up with a compilation. Because it's really not enough to just implement a law or suggest a law. You also have to see how it's working. And it's quite amazing because what you thought of at the drafting table wasn't necessarily the way it was working out, and not always necessarily in a bad way. There were some practices which were good as well. So the idea of documenting those practices, which has been done in a very methodical way by the Lawyers Collective over the last 5 years. I was there for the first 2, but then the last 3 years they've been continuing with this, and they have some very good experience which I am documenting. It's getting supported from the UNTF, which is the UN funds on violence against women, and that has been, it's actually, they've been doing it quite consistently now for the last, as I said, 5 years. And this project which I am doing is to, the whole idea was, even at the very beginning, was that you do it for a little while, but ultimately it's a state's duty to monitor its own laws. So the handbook that I am preparing, we hope will get adopted by the state and the state agencies, and they will take on the job of monitoring how their laws work.